different ways, and one of them is hidden under 29C. DCF is always going to say it's an emergency because they file their affidavit under section 24-29. They cover their butts all over the place.
99% of the time.
Right. But you could also bring the case back and say it's not an emergency. So these other questions are just as valid. If we could put a service in place for this kid to be home, so they could prove their case, but you could show, but all she needs is $100 for food. Why can't the kid go home?
Reasonable efforts.
You get it? So you will take all these things you've learned in law school, but you're going to do what he's saying.
It's too nice.
Are we getting too detailed?
No, I have a question actually. When are the times that what are some, well, let me ask you this way. Do you often have your clients testify at 72-hour hearings?
I don't. DCF does. Some of them want to tell their story. Right. They tell me their story, and I said, "Oh God, no."
Yeah. Okay. That's why I brought it up.
And like I said, you are going to have a meeting with your client for two reasons. You're going to have a meeting with your client for you to know what the heck is going on. It's called investigation, and you're going to bill it as an investigation or client contact. But the other one is to, and there's a reason he's going to tell you about that.
Okay.
About the billing part. There's another reason you want to talk to your client and talk at length. None of those 15-minute meeting with my client before a 72-hour hearing. You know, mine say 2, 3, 4 hours with my client before a 72-hour hearing. And I often hear from CPCS telling me,
you spend too much time.
Too much time. Like, I wouldn't have done it any other way with a private client. And it's because you need to prep your client for being asked those questions by the DCF attorney. You need to prep your client to not say, but this person told me. You know, you need to sensitize your client to what she can say, what she cannot say, not to volunteer information, to answer the question, and you train that person.
For example, you get a mother who says, my son is just such a pain because he never listens and he totally disrespects me. Now, if that woman was saying that in front of the court, she's done. However, if you can see after talking to her that she's got 10 years of working with therapists and special ed and banging on doors in the bureaucracy, and this woman has never given up, but this is what it accumulates to in her short story, because that's all she's doing at that point. You want to slow her down and teach her how to present it differently.
I have a story where a mother, she was manic in a hospital while her child was getting surgery. And she was soliciting sex from the doctors, and she just went crazy. And I represent the child. Of course, this child is of age, and she tells me that—
How old is the child?
13. I'm trying to give us little identify information, but I guess the age is 13. Child is 13, and she tells me I want to go home. So I said, okay, so I got to try to get you home. So I, with the permission of mother's attorney, I asked her a few questions, and I noticed she was a little talkative. And I asked her mother's attorney, may I? She knew what I was going to say. If I ask you, do you have time? What are you going to say? It's too very. Do you have the time? Yes or no? Oh, she got it. We went into the courtroom, which was a little room in the basement of this courthouse.
And this is for the 72?
For the 72.
Okay.
And the DCF attorney asked her one question. Half an hour later, she is still talking to the point that she's saying, I will kill, maim. It was like, and the DCF attorney is looking at me across the table saying, like she wants to leave. She wants, we're done. Please make her shut up. You asked, wait. I swear, we were there for 2 hours, and she got to ask 2 questions, and it was. You need to train your client, prep your client for, and make them understand the importance of having. Just answering the question that you're asked, and nothing more.
You're spending time and money now getting an education on an academic area that's going to make you very specialized. Many of your clients in these cases are in an emotional situation. They can't box their way out of the bag half the time. You're so upset. You have to take your knowledge and you have to boil it down into, ma'am, if I ask you a question, give me as much information as we talked about today. If the agency asks you a question, you say yes or no, and let me fix it later. And when you get nervous because you've done an hour of yes and no, please let me fix it. Okay? And that comes right out of your civil procedure. Okay? Massachusetts has an unusual statute in that you can ask anybody anything on cross and direct, but not on recross and redirect. In other jurisdictions, if you plan to do that, work in other jurisdictions, that's not always the case. But that's a good, safe rule. Tell them when they're being, even if they're a hostile witness, you're going to take that body of knowledge you have and get it down to a simple direction and keep focusing your client on it. Now, in Marco's case, he wasn't his client. The woman was manic. And this is the reality of many of the cases. So you have to put that into the hopper. When you're prepping a witness, one thing people forget is one of the things you're doing as a lawyer, I'm sure you remember this depending on where you are in your education, is you are assessing evidence, all the time assessing it. Is it good? How does it pair up to the other side? How will it appear in court? So you can prep a witness. I've had professional social workers, military background, that go and get LICSWs, prep them for an hour. We hit a point in the preparation where I can't make a diagnosis. This was in Maryland, and I was the presenting attorney for the agency. Can't make the diagnosis. If the law says you can. My agency says I can't. Let me show you the law. Let me show you this. Your agency's doing it for their insurance purposes. You're allowed to do it. And it passed all that. Professional, war veteran. He's up on the stand. There is a mother's attorney that has a great court presence. And she's insisting, and I'm saying she because it only makes sense if you understand it's not get physical. She has stiletto heels on. And she keeps, after a while, the guy is just like, she did her job well. She used everything in her toolbox. When I said to him, what's the diagnosis? I can't say that. We had to get the judge to intervene and everything. And he said, I can't. Afterwards, I get him and said, what happened? He said, she got me so nervous. All right? So, when you're prepping a witness and you're assessing evidence, you're doing what you can, but you realize you're going to have to put it into an answer for your question, your client as well. What, you think I'm going to win? We really can't give you any guarantees. But in the back of your mind, if you know they're a bad witness, calculate that. Let them know. You're going to be on a stand. It's going to be nervous. It's going to put you under pressure like you've never felt before. And you've got a lot at stake. Are you comfortable doing that? Yes, no, yes, no, yes, no. All these things will go into it. They're very practical. So even though you can sit here in a classroom and say, oh, I need evidence of this, 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 and this, that's black and white. You may not be able to present that evidence in the courtroom because of reality. You're dealing with human beings. And DCF took advantage of something, but because of their ignorance in his example, and they usually are more ignorant than you are, because of their ignorance of the facts, they didn't realize they only unleashed a time bomb.
Yeah, half the time, DCF, when DCF goes into the courtroom, they go in knowing a lot less than you do, if you do your work. Because the attorney has, 80 cases, and the social worker has 80 cases, and they have 5 minutes with the attorney, give them the affidavit, 2 or 3 51A reports, and they get to read the first 2, and then they go in.
Right. And remember, these affidavits are not written by lawyers. I shouldn't say remember, but be aware. That's why when Mark was telling you, parse them apart, and I asked you the question, is there a cause of action? That's the right approach. These social workers don't know law. They can state 3 pages worth of paragraphs. There may not be a real basis for anything except a gut reaction behind all of it.
You remember that, and when you are going to court, when you're preparing to go to court, always figure out if there is a motion that you should make.
Right.
There is nothing speaks better to a judge, and for the record on appeal, than objections made on paper. See if there is a motion. The first, sometimes I get a 72-hour hearing coming up, And I'm like, oh, come on, I'm trying to find something to write a motion on. And that's my approach. I won't, because it's the best way to present an argument to the court. Here's my motion explains everything. I put my memorandum of law with my motion. I build a lot for that memorandum of law.
Can you give an example?
Huh?
Could you give an example?
I'm going to give you an example right now. At the beginning when we were mentor and mentee, I got this case. It was a chins. Remember, this kid was in the custody of the department because of a chins, and then the department filed a care and protection on the same, basically on the same facts of the chins.
Before you go anywhere, does anyone know the legal distinction between a chins and a care and protection?
They should all know.
There is a very fine but clear distinction, which the agency prefers to blur for monetary reasons. And if Marco hadn't done his homework, what we're suggesting to you, parsing it and checking that there really are a legal basis for that petition, he wouldn't have caught that distinction. But I was not the easiest mentor. I said, go read the statutes. Well, what should I do? I got 5 hours. Go read the statutes. He has to make the argument. I can give him words, but it won't mean anything if he doesn't know how to react to what they're going to say in reply. You need to own the statute. The very basic definitions will get you much farther than you realize. So don't neglect understanding the definitions.
And if you don't understand something, the case law will tell you what it means.
So what happened, Michael?
So what happened was, I wrote this motion saying, you can't do this. You can't file a CMP. Well, you can file a CMP, but the court cannot act on it because there is no abuse or neglect, one. And two, the court has already ruled that this child, that this mother is unable to take care of this child because of the child's behavior.
Right.
But
What type of chins was it that?
it's a
studied?
chins stubborn. Because of the child's
Stubborn
behavior.
home, not school.
No, exactly.
Home, okay, yeah.
The mother filed.
Yeah.
Now, the facts for the chins are the same facts for the CFP. And you already ruled that this kid, the mother's not able to take care of the child because of the mother's behavior, not the opposite. It's not the mother's behavior. Not because of not the mother's child behavior. Not because the mother's shortcomings render her unfit to take care of the child.
Yeah.
And that's the distinction I was trying to make to you before. If a woman gets up and says, my kid's a pain in the butt, blah, 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 it sounds terrible. But if that person has done all this work
Right.
for years and is just burnt out emotionally, a human being,
Mm-hmm.
and that's the best she can explain to people at that point. But you find all this evidence that she's done what she can and she's continuing to do it. So what? She sounds rough around the edges. Who cares? It's not her problem, is your argument. It's the kids.
I had a good client though, and those make a difference. The thing is that you gotta do the work. You gotta take the petition in anything. If you're doing a divorce, if you're doing anything, you take the findings by the other side and you have to break them down, apply the law to them, and have a complete understanding of what those pleadings say.
And that's where your law school education is very applicable. That is your law school exam. I mean, that's what it's about. If you can catch the skills they're teaching you here about the exams, and people will tell you, well, it's not about real life. Well, yeah, that's true. There's a lot of things you're going to have to learn, how to use constables, how to bill and stuff. That comes. But the skill that you bring and the expertise is how to parse something apart. And if you do it from the beginning, you're going to get a better picture on how to handle a case. You're going to know what kind of evidence you're going to need to develop. You're going to use your efforts more efficiently. So this is a seminal skill that you're learning. And the rest of the stuff we're talking about, this may be boring to you now, but when you're trying to win a case, you better know where a constable is on Friday afternoon. Because even if there's no one there that you really want to serve, if it was served at 5 o'clock, on Tuesday morning or Monday morning, I got a piece of paper that says I get a continuance. Who cares if you're not going to get something? There's a reason for doing that, because under the principles of law, you have to have enough notice and time. And you can argue with them. All right? Now, I know you go ahead.
So fast forward, you've lost in the 72-hour hearing, DCFS custody. Now you're going to be dealing with service plans. Can you talk a little bit about that?
Mark has been talking about it all along.
Well, there's two things.
Yeah.
You lost on all issues at the 72-hour hearing, because the 72-hour hearing is about many things, each separate from each other.
Yeah.
And you got the service plan. The service plan is the most important, one of the most important
I'm going to
things.
slow you down. And there's a reason, and it's just
Yeah,
academic.
go ahead.
There's
You
something that
talked-
comes before.
Yeah, you talked about your agency regulations and stuff, and I've said to you, please pull your education together in the class, because this is a unique kind of law. The administrative code, 110 CMR, is a terrible thing to read. You have to read it. I read it all the time. I can tell you what's in there, but I reread it all the time because it's written for contextual reading. It's not a checklist. So it lays out all the obligations the agency has to work from this point to the trial. And there is a whole practice that can happen in this court, as well as administrative practice, that has to be juggled along with you preparing for trial. And it's both evidence and strategic juggling. You're going to make decisions. It's not black and white. All right? So when Mark was going to finish what he's saying, I want you to realize there are many different things we're missing here.
Oh, yeah.
But they're there. And you cannot work without knowledge of 110 CMR, because you can use it to force the agency to work with your client.
It's on fine law. You can get it on fine law, or you could do what we did, get a certified copy from what was it that you?
State House.
State House. I just gave it $14. I got it.
But it's important, because if you do not file those motions under 110 CMR, 12 months out, you may have waived rights to hearings under the Supreme Court ruling. So it has a repercussion we're not talking about right now. That's why I highlight it. You could be waiving your client's rights.
Slept on your rights. You didn't raise them when you should.
And even if you lose, it doesn't matter. You made the record, and that's all you need to do is make the record. I never waived them. I made the record. The court ruled against me, but I have been alerting people all along that there are issues here.
And there are many reasons to do that. One of them is sort of preserving is that once your client loses the trial, he's going to claim ineffective assistance of counsel. And if you made a great record throughout the whole CMP, the appeals attorney is going to look at all your work, is going to respect you, and it's not going to go there. See what I mean? But as far as the service plan is concerned, there are many things that go before the service plan.
Yes.
You keep talking. I'm just going to.
For example, to understand the importance of what comes before, you got to understand the importance of the service plan. The service plan is what the department is going to use in court to tell the judge, and everything's to tell the judge that you didn't do what they expected of, that the mother didn't do what they expected her to do and had told her they expected her to do in order to get her kids back. Remember, the department has a duty by law to try to reunify child with the mother, and I'm always going to use the mother as an example. And if they don't do that, they lose their funding for that case. That's thousands and thousands and thousands of dollars that they're not going to get reimbursed for. So they need, the mother has to have notice, the parent has to have notice of what is expected of her in order to get her children back. It's a little more complex than that, but it's basically what it boils down to. So the government, the department is going to give you a set of tasks, goals, and expectations that they want you to that they want you to do in order to reunify the child with you.
Okay,
Now,
just quickly, you know
And
about
this should
51
sound
A's?
familiar to all of them.
That
because we've
51
done-
B's?
yes.
he's talking under assessment.
That leads to this.
Yes.
That goes to where Marco is. All right, this is where we are in the administrative 110 process. There's a lot of details about where this is, but I'm trying to overlay it so you see where it relates to each other in time. These are really, really important work items you cannot ignore. You put them on in every file. Did I get this? Did I get that? Did I do this? Who did the assessment? Who did the 51B? Is the assessment appropriate?
How long ago?
Most of these workers are not social workers. They're only allowed to be called social workers because of the statute. Anyone else who walked around the world and tried to call themselves social workers with the credentials of many of the DCF workers would get in trouble because it would be called malpractice. They are not social workers. So they're making social work decisions, though, that will lead to this task. And that's what Mark was trying to tell you. And I'm trying to tell you, check this as you go, because this may be way off.
So the service plan, how do you understand how the service plan, how important the service plan? You got to understand that the service plan is built on something. Just like the affidavit was built on an investigation conducted by the social worker, by law, the service plan is built on an assessment. How can you say what is the clinical solution to this problem if you haven't investigated the problem itself? So what you need is, you need to take a look at the assessment. One, was there one made? Two, when, by whom? How many visits to the mother, to the father? How many collaterals did they talk to? Are there any conflicts of interest between the collaterals that were talked to and how much they rely on those collaterals to, I mean, there's a whole bunch of questions. You got to study that assessment to see if it was properly made and did it identify the problems that this family had. For example, if you have a mother whose child were taken away because of her inability to keep the children safe from predators. You know, she keeps getting mad, new boyfriends in the house, and there are allegations of some improper behavior. But the service plan only addresses drug use. There is already an allegation of the child not being safe for the inability of mother to keep those children safe, but you only address through the service plan the drug issue. You may address it to the satisfaction of the court, but if you just went by that service plan and you never addressed that other piece because DCF didn't want to address it, then when you get to trial, are you going to convince the judge that the children will be safe with mother once, if the judge were to return them home? No, because that was never addressed, but the allegation is still there.
And the real question you'll have as a lawyer on the other side, and this is where judgment comes in, you're going to have to hone that skill of judgment. There's lots of ways to deal with the fact that they're not addressing an issue. You could bring an administrative hearing and make them fix the service plan, but is that going to help your client any necessarily? Isn't it a waste of your time? Or could you make sure your client gets services so that when it comes time for trial, you have evidence that it was addressed?
Exactly. There's many ways of addressing this. You could do both.
You could do both. It's a strategic call. For some, it's very important to realize your insight is going to be unique. Each and every one of you will have your own insights. And you're going to have to make these calls. And when somebody reads it, like often as a mentor, I'll sit in a courtroom and I'll know the case and I'll know why a lawyer does it. And a lawyer will sit next to me and say, why are they doing that? You cannot judge a person unless you know what strategic calls they're making. And no one can know that because it's largely yours. Right? Even your client may not understand all of it because of evidence rules, because of civil procedure concerns, because you're making a record for appeal, because you know it's going to appeal, so you want it to look this way, not that way. So there's always going to be this strategic dynamism going on in the case. But Mark was right. You're going to have to make sure that the issues are addressed. Remember that this whole area of law exists because of a simple philosophy. The U.S. Supreme Court said the government can intrude in these situations to protect a child's rights, but it cannot just rip a family apart. The basis of the power and the reason the Supreme Court, one of the reasons they said you could do this is so that they can try to address it. And then if they can't address it with reasonable efforts, then they can move beyond that family unit. But they have to address the underlying issues first. So if you're not sure of the technicals, and you're sitting in court and you're just saying, something's not right here, or you're working on a case, you're saying, why aren't they doing this? Don't ignore that gut reaction. Something's supposed to be happening to address the underlying problem. We've done a lot of talking, so what time's the class end?
2:15?
Okay.
2:15, 2:20. Why don't you maybe segue a little bit into the Chins cases as well, where the department is involved, and if you represent not only the child, but now parents as well?
Well, let me just put it this way. Chins is a circus, and I'm getting up because I'm just going to clear this out. Is it all right? You guys don't need
Chins
this,
is a
right?
circus.
Chins is a circus, and Marco's experience is one courtroom, Lowell. What he's told you is true for Lowell. I practice in Lawrence and Salem, and I'm telling you that none of the courtrooms do the same thing. Chins is a whole bunch of mess. So in Lawrence, these kids wind up with Chins findings against them because everybody's lined up to make sure they have a finding, and the court gets what it wants, control. In Lowell, that's what it's set up that way. Even the parents, the kids roll over.
The illusion of control.
Right, but that's what they do. They want everybody on the same page, and as long as the parents are saying yes, no one will file care of protections. In Lowell, that's social work. Let's all hold hands and sing. But maybe something will happen. Whose job is it this week to do it? And the statute tells you one thing, but the reality is something else. I was telling you, Professor, I actually met with the woman who was in charge of the subcommittee when they were rewriting the last law, and I said, would you please clarify in the law who's supposed to present the case?
I know.
Because the law says what's supposed to happen, but it's not clear. And probation is actually presenting the cases. They're not the presenting agency.
The school department.
It's a truancy. Who's supposed to present the case?
Right.
Now, I have one case right now. Maybe we'll read it.
Mm-hmm.
Your Honor, you never perfected the Chins. A year into this case, I'm appointed in the C&P. Everyone talks like it's a Chins. There's a probation officer who's done squat. He wants the agency to do something. The agency doesn't want the kid. The mother's got her hands full. And the bottom line, after all this, is I'm looking at it, and he said something to me. I said, Your Honor, I'm not appointed on the Chins. I said, well, I'm appointing you. I said, well, Your Honor, it hasn't been perfected. No one knew that. In all their year of holding hands and singing Kumbaya, there was no perfected petition. There had been no issue of anything. So there was nothing there. But the school didn't even realize it. Because when I went, the one school that issued the petition, they transferred the kid because he was such a pain in the butt to another school who was trying to social work the case. And no one realized nobody was going for the school to court. Now, to this day, nothing's happening, and I made sure of it, unless Jane Moshe Conte, and maybe you want to bring her in here, is in that courtroom. Because I want, anytime we have a hearing, I want the attorney. I don't want an attendance officer. I don't want probation. Nobody wants this case anyway, and that's why I can do that, because nobody wants the case. So if anybody has to say anything, they need a lawyer. But generally, the Chins are a mess. Probation will get up and make a report. The court will make a report. The kid's standing there with a lawyer, and the kid has all kinds of issues, and the parent doesn't have a lawyer.
Unless.
Does anyone know?
Unless there's a question of whether custody can be taken away.
And what have you learned in class about when that actually happens? When does that arise, that right?
On the day that they want to. I'm sorry. On the day that they want to take it, that's when they appoint you.
Attorney Torres, come on in, take a case. And you're standing there. We're going to give the custody to the department.
I'm sipping on a Slurpee in the lawyer's room, packing my stuff because I just had my case heard and I'm leaving. And Attorney Torres, I'm going to take the case down. Does the judge know that I'm here? Like, yeah. You go in, you take the case, they take the case, they take, I got in trouble with one of the judges for a little while, because they assigned me, that was true, I was sitting on the survey and just grabbed me in, and this is your client, and I'm like, oh really? And there's a hearing, and we're going to go on it. Well, I need to talk to him. So I go outside the courtroom with him, and what is he going to do? I want to stay at home. My mother doesn't want you home. I don't know what she got in return, but she doesn't want you home. And I'm like, okay, I want to stay home, blah, blah, blah. So tell me what happened. I swear, not 5 minutes had passed when the judge called us back in. I had 5 minutes to prep. And I told the officer, tell the judge that I'm not finished. comes out another time, I don't practice fast food, and that was my mistake. I don't practice fast food lawyering. This is, I need to talk to him. What's your name? And I was a little sarcastic, but they put it up for the next day. So that was good. Because I was taking too long. But it is that way. It is that way. So you need to be familiar with the best thing that you can do in order to prepare for a case is to have always in your bag an empty packet for a case. And this is what you have in that packet. You have an information sheet, a client information sheet, a lawyer's information sheet, lawyer who for who, lawyer who for who, and it's all blanks. The docket number for the case, the date of assignment,
Blank releases.
blank releases, that's very important, blank motions. Because if you needed to file an emergency motion right there, right now, or you needed the judge to authorize something, you have this nice blank motion that all you do is fill it up. You have releases from your client to accompany that motion, or you have an affidavit form already there, because your motions as always have to be backed up by some type of document. And the best thing that you can do to handle those situations on the fly is to have that with you. Because your client might tell you something now among 1,000 things, and 2 minutes later you forget it. But if you're writing down, if you have that packet, it will help you.
I guess what Mark was describing is something you need in any good business. You need a system. Something that you know you can go back to all the time, and you understand that it's going to be ready to move forward. It makes you more efficient. After a while, some of these cases start sounding the same, but if you have a system, you're getting releases, you're sending your subpoenas, you're getting your records. Really what you have to do when you get to the office after you've spent the whole day in court is say, here's the file, everything's subpoenaed here, I've got a to-do list, I've received this, 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 and this, I haven't received these, I need to make phone calls on these. You make your phone calls, you put the file away, you move on to the next case, you keep going. Because when you're tired, if you don't have notations in that file to yourself, you don't have time to start pulling it apart, because you're mentally going to be fried. But on the chins, I want to lead into what you're going to go into, is the school suspensions. Chins is basically anybody's kid who doesn't get along and no one can control. It can be filed by a lot of people. As a practical matter, what we're trying to tell you as a joke is the law is a quagmire, soft underfooted animal that you're going to have to deal with and know in the courts where you work. It is there, it is in statute, they have different criteria, but the most important thing you should know to protect yourself, and remember the conflict, the ethics, this will raise ethically. If you're protecting yourself, you automatically have some kind of ethics conflict with your client. But to protect yourself in this instance, you are protecting your client. Look at the timetables. At least get those down from the Chin statute. When do the rights trickle in? It's unclear when a parent gets a right to a lawyer. Get the case law. Okay, it's been developing. I know you have Michael Kilkelly here. He's been one of the lead appeal attorneys on a lot of those cases. So if you just go into your research thing and do Chin's Kilkelly, you're going to find a lot of them. All right, but there are timelines. Again, it's this procedure. You're going to get some kind of notice. There's got to be a show cause, some kind of hearing, and then you're going to have the timetables click in depending on where you are. And when I say click in, I mean make a tickler system for yourself. Okay, just keep it in this file that Mark was talking about, this dummy file that you could use anywhere. Just call it Chins. And in it, you should be able to go into the court and say, Your Honor, you just issued this petition. I have so many days till I have a right to a trial. I also need discovery, blah, 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 blah. Even if you get thrown into this situation because you have a system and a checklist, by protecting yourself, showing you're doing what you should be doing as a lawyer, you are getting your client enough time to prepare the case. If later you decide for strategic reasons to change the approach, that's strategic. You've had your time. But as described, you're just pulled in and your client will pay the price. Okay? And a lot of lawyers now are getting these claims of ineffective counsel against them because it has become the tradition just to do this stuff to move the courts through. They're not doing anything wrong because it's the context of the case. They do work it out behind the scenes, but none of that gets in the record. And when someone gets hold of this, they take it up to the Supreme Court. That lawyer is stuck with a record that everyone in Lowell knows what it meant, But anywhere else, it looks like malpractice. So that's where that ethical conflict, they'll give it to you in the ethics exams probably, about if you're protecting yourself versus your client. That's a good guide in chins. Get that filed together with the checklist. Okay. Now, the reason I wanted to segue this into what you're talking about next to suspension is one of the problems you're going to deal with in chins is the truancy. Truancy is one of the reasons that the school becomes involved, but it's not the only reason. They're going to try to suspend kids as well for various reasons. This crosses over two areas of law. This is chins and it's administrative hearings. Okay? In both of these situations, both of these can show up in any care and protection, in many forms and permutations in the juvenile court hearing. You have to learn the definitions and how to break them apart. Some of these kids will come in as a care and protection because the school is tired of trying to get the kid to behave. And if they call the DCF often enough, it's the mother's fault the kid isn't lined up. It's the father's fault the kid isn't lined up right. They want the kid on medication, it's a care and protection because the mother and father didn't get the medication. It's a truancy after that because the kid and the mother the kid is so afraid of going to school that he won't go to school anymore. This goes on long enough, the kid has a record, and the kid can be, clinically speaking, reinforced for doing bad stuff by everybody. So it becomes a truancy. So when you're dealing with these suspension hearings and chins, Marco's statement about investigation, knowing the details as you talked about, and putting it together with the law as you had talked about, is very important. Okay, I know this is a vague general statement, but it is left that way because of timing. But it is important. Without those details, you're not going to be able to pull these apart. Often you'll say, Your Honor, this isn't a care and protection. You'll file that motion, dismiss this. You may lose on day one. 3 months later, when everyone else is caught up with you, yeah, Your Honor, we should dismiss this case. You've sowed the seed. It's a chins. Well, it looks like a chins because of truancy or bad behavior, but it's really a SPED case. And they didn't want, they somehow through a back door helped the kid not come to school. It's not our fault. The kid didn't come to school. We can't do anything. It's a little bit of everybody's problem. And if the school really had a case, they'd be sending lawyers to court. They don't. They do this, get the kid out of the classroom, take him somewhere, and then they don't do what he wants. Even if you have a CMP kid, a true CMP case, where the kid is being suspended from school now, you have to be able to develop the practice to know what to do with the suspension. And I always get it the half in the wrong place. It's 30, I'd say 37
and a half, and then 37.
Right, and that's the area of law where you need to look at for this. And I know that's what your next class is supposed to be about, I think.
Well, then we'll be starting delinquencies. So we talked about 37H and a half way back, remember, when we did the student cases.
But it's going to fall in here. You're going to have a working knowledge of it. In fact, it got to be, they used to tell us you can't do any of these things because you're not appointed to. Then a few years ago, they changed it. And we were at a meeting just the other day on this, and I asked the people now in charge, because they're now bringing in-house all the counsel that used to be consulting and pro bono. They're now bringing them into the Committee for Public Counsel. And so I said, well, if you're going to do that, can we get an updated written document on where our responsibility ends? And if you're going to do this, because all these areas of law meld, the best they could say to me was, well, you can do everything except go to the administrative hearing. And one lawyer joked in the back, he says, yeah, and if you filed the petition like you're supposed to, you're now on the hook, because you've got to go there. So Marco kept saying, I've talked about billing, and the last thing that you do have to be aware of, and we've got 1 minute, is all of this is going to be in the context of business. You are always accountable. So even if you're doing public interest work, someone is going to ask for an accounting, and you are going to get an unfair deal in the press and in money. So I go back to what we started with. If you want to be a corporate lawyer and you feel good about doing that stuff, that's where you should go. But if you come home from a bad day and you get an audit notice, as we do, and you've worked your butt off, for me, I know I'm doing the right thing. This makes me feel like I'm doing something helpful. So I can put up with the audit. I can put up with the bad day. But it comes with public interest work. And what we're talking about is public interest work. And the appointments usually come through the Committee for Public Counsel, CPCS, if you're a private attorney, because they don't have enough. But now they've been mandated to hire enough attorneys, but they can't get enough. Your graduating classes will probably be solicited by this agency if you're interested in this. So they'll bring you in, you'll get your experience there, and we don't know if the private counsel bar will still be assisting. Probably will. But if you're working with CPCS, a lot of these billing issues won't mean anything to you. but watch what you have to learn, because law school will not teach you these billing and business model issues.
Important. Extremely important.
And the reason this is important, and I've said this to Marco and every other mentee I've ever had, do not take on too many cases. You're not a superhero.
Right.
You will not do justice for yourself or your client in many, many ways that I can't even go into because we're out of time.
Just one quick thing. I have a friend, we have a mutual friend, works her butt off on cases, bills less than $2,000 every month.
Because
Why?
she can't keep track of her bills.
She can keep track of what she put into. So she calls me, did we talk this month? At least she gets $100 more on her bill, but it's extremely important because you're doing this as a business. Yeah?
If you are being appointed through CPCS, so the judge is appointing you to these cases, how do you go about saying no if your workload gets to be too much?
Don't put yourself in the book.
Okay, so you
You
so
sign-
do you have like
it-
duty
it
days
depends-
though?
Oh, well, that's for
That's
Delinquency
different.
attorneys will.
Yeah,
Okay.
that's for
All right.
delinquencies.
Okay, so it's separate.
Don't put yourself in the book. If you can't take it, just call them immediately. Don't wait 2-3 days.
Not all courts have books. You can turn them down, but don't turn them down too often. Right now, there isn't enough work for lawyers, but a lot of these lawyers have developed a volume business. When you hear them talk about there's not enough work, you remember all the stuff we had up here? You can work, and you can do 10 cases and work your butt off non-stop. The real trick is juggling them so that there are different phases of development. And you want to have 10 to 15 active cases. You stay sane, you can get good focus, you bring good karma to your meetings, which you need. You've got crazy people, literally. You've got to help them calm down so you can give them effective counsel. You know they heard you. They can make decisions so that you can do your job correctly. And they don't stand up in the courtroom and say, I didn't tell them to do that. And they will.
And they will.
And by bringing them down, you avoid the fast food lawyering.
And you build in trust. A lot of these people aren't functioning because they don't trust the world.
I had a client who appealed, and he told his lawyer, the appellate attorney, no, I have no issues with my attorney. I hunted him down. He gave me false addresses. I hunted him down wherever he went. It turns out that when he appealed, of course he wasn't even at trial, when he appealed the decision, the guy loved me. But it was because he understood he understood my effort to try to help him, even though he knew that he was not cooperating with me.
He didn't appeal for any real reason. He was
Just appealed to him.
He was appealing to appease his wife. We'll put it that way.
Thank you.
Thank
Because I mean, Mark, you can go.